Okay, it's just gone 3. Good afternoon, everyone. I'm going to get started with welcome and introductions while people continue to sign on, but we'll make a start and make the most of the hour we have. So my name is Lisa Carlson. I'm the Chief Executive of the Business Improvement District in Canterbury, and I'll be hosting this session today, this meeting session, together with my colleague Rachel Pillard, who's our Marketing and Communications Manager. We typically hold training sessions as the BID between January and March every year, but since the crisis began, this is now, I think, our 14th session where we've met together either in our In Conversation series or for a series of training sessions on a range of topics, everything from marketing to law to business rates. And if you've missed any of these, we do record them and keep the slides on our website. That's canterburybid.co.uk. And we also send out a weekly e-news with city centre updates, for example, the latest information on city performance like footfall, things like government grants, which I'll touch on at the end, and also marketing and training opportunities. So please do sign up if you don't receive those already, and you can do that on our website. So our speaker today is Lee May, who is a partner in commercial property at Brachers. And so Brachers, in addition to their office in Maidstone, now have an office here in Canterbury. So Brachers and Lee, we welcome you to Canterbury. And it's also the year that you're celebrating Brachers' 125th anniversary. So congratulations on that, and we're delighted to have you in the city.
Thank you, Lisa.
Lee has over 20 years experience advising clients in relation to planning, environmental law, and health and safety, and he acts for businesses, developers, landowners, and local authorities. So a wealth of experience in this area. We're also being joined today by Karen Britton, who's the planning manager for planning policy and heritage at Canterbury City Council. The council's currently working on the development of the new local plan for the Canterbury district, and more on that in just a second. So the purpose of today's session is to brief you on the latest changes in planning legislation nationally, including the class use system, and potential changes to government policy in the new planning white paper, and particularly how these could impact your business, but also us as a city. So in addition to that, as I mentioned, in addition to national government policy changes, Canterbury City Council is in the process of developing the new local plan, which is also incredibly important to how the city works and how our businesses and organisations within that can function. That's why I've asked Karen to join us today, so we can touch on that local plan process and why we all need to be engaged with it. But first I'm going to hand over to Lee, who's going to brief us on these national government changes and how it might impact us. We'll then take some time for questions, and I'll then ask Karen to say a few words about the local plan. So in terms of questions, if you think of things as we go, please feel free to pop them into the Q&A. So don't save it for later. If there's something on your mind, just pop it into the Q&A, and Rachel and I will monitor that. If you've got a technical question, pop it into the chat. We'll try and help, or if you want to share something with the group, that's fine. And as I said, let's all just keep ourselves on mute when we're not speaking, so we don't get that feedback and background noise. But for now, I will hand over to Lee, who's going to speak today on planning law. Thank you, Lee.
Thank you, Lisa. Right, first things first, let's try and share screen. And hello to everybody, by the way. So, share screen. Can you all hear me, by the way? If somebody can give me a little wave just to tell me that's good. Good. Hello, everybody. Right. Can you see my first slide? Does that come up okay? Good. Okay, right. Well, yeah, thank you, Lisa and the BID team for the invitation to speak today. It's very good of you, and thank you for the welcome to Canterbury. We've been here for about, well, since just before lockdown, unfortunately, so the timing wasn't perfect, but we're very much enjoying our time in Canterbury so far. What I'm going to talk about today are some changes to planning law, and also some existing changes, and also some forthcoming changes set out in the planning white paper, which a number of you may well have already come across. And the particular issues that we're going to look at up on the screen there, topics for discussion. So first of all, changes to planning legislation. That's principally and mainly going to focus on the changes to the use classes order and the introduction of what's called Class E within that order. And now that may mean something to you, or it may mean nothing to you at the moment. I'm not sure what everybody's sort of familiarity with the planning regime and the use classes order is, but hopefully by the end of this session, you'll be familiar with it and what the impact of the changes that have just come about will be for the city. Then also, I'm going to touch on the some other changes which have come in recently, which are to do with physical development and essentially the government introducing the right to extend buildings upwards. And then I'm going to finish on the planning white paper, because that's something on the horizon which could impact very significantly. But like I say, the majority of this will be on the use class E, and then I'll just touch on these other bits a little bit more briefly. So I mentioned the use classes order. It's a rather obscure piece of planning legislation. So unless you're actually familiar with the planning world, it probably isn't that familiar to you. So I thought I'd just do a quick recap on what that is. Generally, planning permission is required for the carrying out of development on land. And development is divided into essentially two categories. You've got physical operations, building things, and you'll see that in the definition just below the first line there. But it also incorporates the making of a material change in the use of land. So you've got these two elements to development: building works and a change of use. And what the use classes order does, and this is a piece of legislation from 1987, is it divides various uses up into particular classes with the intention that if you're using a particular piece of land or a particular building for a use within a use class, then using the building or piece of land for any other use within the same use class does not require planning permission. So essentially you can switch from one use to another without having to trouble the local authority. Now, there are all sorts of use classes, and I'm going to go through them shortly. But the example which I've picked on just for present purposes is use class C1, and that covers uses of a building as a hotel, as a boarding house, and as a guest house. So if you have premises which are a hotel, because within the same use class you have boarding houses and guest houses, you don't need planning permission in order to switch between those various uses, albeit they're actually quite similar anyway. And that's probably the point, really. The government are happy for people to use a piece of land for a particular use, even if it's slightly different from what they're using it for at the moment, provided it all sits within the same use class. And then there are also this species of things called sui generis uses, and those are uses which do not fall within a particular use class. So that's just a sort of very broad brush summary of what the need for planning permission is and what the use classes order does. And it'll probably make a bit more sense if we actually look at the use classes order itself. Now, the change that came about recently came into effect on the 1st of September this year. So what I've done on the next couple of slides is I've set out what the use classes were before the 1st of September this year. And then I'll go on to explain what changes have come about. And you should hopefully see from that why this is important for town and city centres. Because as you'll appreciate, if a particular premise within the city centre is being used as, for example, a shop, well then what other uses can that building be put to without having to get planning permission? And that's what the use classes order does. So you'll see that, and the changes to that use classes order obviously have knock-on consequences for the functioning of the city centre. So you'll see on this slide, I've set out use classes A1 to B8. I would quickly jump forward to the next slide, and that sets out use classes C1 to D2. Now, prior to 1st of September this year, those were all of the use classes. And if we go back to the preceding slide, so starting off with, for example, A1 shops, the use classes order identified shops as being use class A1, And you'll see that in the next column there, examples of what that means would be premises used for the retail sale of goods, but also as a post office, travel agent, hairdresser, funeral director, and internet cafe. And there are a couple of other examples as well in the legislation. So going back to the purpose of this order, what this means is that when a premise is being used as a shop, the owner of that shop doesn't need to get planning permission in order to turn it into a travel agent or a funeral director or an internet cafe, because those are within the same use class. Then moving down the list, you'll see that there are other types of uses that have been clustered together into these classes. So financial and professional services, restaurants and cafes, drinking establishments, hot food takeaways. Those are the A use classes. And you'll see that different types of use are within different use classes. So, for example, if you wanted to turn your shop into a drinking establishment, because it's in a different use class, that change constitutes development and therefore you need planning permission. It is a little bit more complicated than that because there are what's called permitted development rights that enable some changes of use between use classes to happen, but we're going to get into some very, very long grass if we try and delve into all of that. But for present purposes, we just need to think of these use classes as being species of use which don't require planning permission if you stay within them, but possibly do require planning permission if you move outside of them. So you can see how local authorities, in our case Canterbury City Council, can use this in order to ensure that the city centre has a particular look and feel about it. Because on the primary shopping frontage, it may say, well, we're only going to allow A1 shops, also maybe A3 restaurants and cafes, and perhaps drinking establishments, but maybe on a secondary shopping frontage or in certain parts of the city, we'd prefer, or we'd be happy to have other uses as well. So that might be takeaways or the sort of the A2 uses, the banks and building societies. Now that's just an example of how it might be used. I know in Canterbury, for example, you've got a combination of all of these uses in various locations throughout the city centre and along the high street in particular. But the point I'm making is that this is a tool that the local authorities can use to regulate how particular uses are distributed around the city. So then moving down the list, then we move into the B use classes, and you'll see there's B1, B2, and B8. So business uses, light industrial, for example, and then B2 is general industrial. And the distinction between the two essentially is whether or not those uses can be satisfactorily carried out in an area without an impact on the amenity of that area. So essentially making sure that B2 uses, general industrial, aren't located in areas that are going to impact on residents or other businesses. Then moving down to the other list, then you've got the C use classes, and these are all essentially residential in nature. So hotels, C1, residential institutions, C2, dwelling houses, C3. So, your normal terrace or detached or whatever house would fall into that use class. Then you've got HMOs as C4, and then moving down to the D use classes, you have non-residential institutions and uses for assembly and leisure. So you can see, for example, on the assembly and leisure, you've got things like cinemas, gyms, and then in the D1 use class, you've got things like medical centres, art galleries, and indeed law courts. So that's been the structure and is the structure for how uses are divided up into various classes. I mentioned you've got sui generis as well, and those are anything essentially which isn't in one of those use classes. So what did the government do to that regime? Well, from the 1st of September this year, this piece of legislation came into effect, and it's the Use Classes Amendment Regulations 2020. And what they did was they abolished all of those A use classes that I mentioned, so shops, financial and professional services, restaurants and cafes, etc., pubs. All of those use classes have been abolished. It also abolished the B1 use class, which I mentioned, which is for the businesses and light industrial, and it also abolished the D1 and D2 use classes, and it amended the list of sui generis uses as well. And what it did was it replaced those various use classes. It left the C use classes, for example, untouched. But it replaced all of those other use classes with three new different use classes. And they are Class E, Commercial and Business Services, and then Class F1, Learning and Non-Residential Institutions, and F2, Local Community. And you think, well, that's all very interesting. It all sounds rather dry and academic. What does it mean in practice? Well, if you remember going back to my comment about the purpose of the use classes order, this is to enable a landowner or whoever occupies the property to move within a use class without the need to get planning permission. So if you change the breadth and the scope and the list of things that fall within a given use class, well, then what you're doing is you're changing the breadth and scope of what people can do without the need to get a specific grant of planning permission. So by creating this use class E, they've essentially opened the door for the occupier and the owner of those premises, or whoever has control of those premises, to change the use to anything within this particular use class. And what use class E does is it includes quite a number of things which were originally within some of those other use classes. So quite a lot of all of the A use classes, a lot of those are now within E, and also a few bits from the D1 use class. Some of those have also gone into E as well. And what I've done is I've just on this slide and the next slide, I've set out the list from the legislation of what's within that E use class. So you can see, for example, the display sale of goods other than hot food, principally to visiting members of the public. That's essentially a replication of the original A1 use class. So that's all been subsumed within this new use class E. And then there are lots of other things. So you'll see that further down the list, financial services, well, that used to be in A2. So now you've got a use class which incorporates both A1 and A2. And then you've also got, so the second on the list there for the sale of goods to visiting members of the public where consumption is on the premises, that's essentially what was originally the A3 use class. So you can see that the effect of this is to move create lots of potential for a premise owner to move within uses which were previously in separate use classes without the need to now get planning permission. I'll just move down to the continuation of that list of items that are now within use class E. And you'll see there, for example, for the provision of medical and health services to visiting members of the public, also a creche or day nursery or day centre, for an office, and that's what you'll see under that list there is essentially principally what was originally in the B1 use class. So you can, and those two earlier examples, medical and health services and creche, those are taken from some of the D use classes. So you can see that by incorporating a lot of what were previously different use classes into one place, they've created much more breadth and scope for people to change use for their premises. I'll brief, and I mentioned that there's use class E has been introduced and also F1 and F2. So I'll just briefly touch on what F1 and F2 contains. Class F1 is a new use class for learning and non-residential institutions. So you'll see the list of things that within that use class on the screen there. And then if I jump down to F2, then there's a list of the F2 uses. And in fact, I can see that there's an error on the slide there. That should say local community use rather than learning and non-residential institutions. So apologies for that. I'll correct that before we circulate the slides. So, but you can see that what's within that local community use is things like local shops, which is that first item there, halls and meeting places and areas for outdoor sports and recreation, etc. So that's within that F2 use class. Now, again, that's all quite a lot to get your head around. So what I've endeavoured to do on the next couple of slides is to show how this translates from the original use classes order. So this is now, so whereas previously I was describing the position before the 1st of September in those earlier slides, we're now looking at the position from the 1st of September. And you'll see that, as I mentioned before, B2 and B8 have remained unchanged. The C use classes have remained unchanged. But then this is where it sort of gets a little bit more interesting. And I think this sort of hopefully demonstrates in more digestible form the impact of the changes we've seen. So all of these uses which are down the left-hand side there, so all of A1, all of A2, and all of A3, and all of B1 are essentially now within this E use class. And then I've picked out the bits from use classes D1 and D2, which are now within the E use class. So essentially all of those items you can see on that list there now in the central column are all within use class E, meaning that, as I mentioned before, it's possible for a landowner to jump around within those uses without having to get planning permission. And we'll have a little think about the consequences of that in a moment. And then on this page, I've summarized what's within the new F1 and F2 use classes. So essentially, F1 contains elements of what used to be within D1, non-residential institutions. And then F2, local community use, that contains some elements of what used to be within D2, but also this concept of these local community shops, which historically would have been A1, but now we look at as being within this F2 use. And I mentioned sui generis uses. Now this is something, and I apologise for the brightness of that slide. This is something which is particularly relevant for town and city centres. Now you'll recall that prior to 1st of September, A4 and A5 use class for drinking establishments and hot food takeaways, those were within those use classes. They're now considered to be sui generis uses. Now what that essentially means is that planning permission will pretty much always be required for a change of use to or from those particular uses. And then you'll also see that some of the elements of what were in D2, assembly and leisure, those have now been taken out and become sui generis. So cinemas, concert halls, bingo halls, and dance halls. And then just as a health warning, so that you don't think that's the entire list, there is a fuller list of sui generis uses within the legislation itself. So I've just referenced that at the bottom of the page there. So that's a real canter through what the changes were to the use classes. And what I would perhaps do now is just flag up some of the issues that this presents for Canterbury city centre, but also for other town and city centres. So I've given some examples of the consequences of this. So as I mentioned before, it's now possible under the new regime to convert from a shop, for example, into a cafe or a gym without having to get planning permission at all. So as I've put on the slide there, will that result in more coffee shops? Will that result in the loss of retail? You know, a landowner is going to clearly want to maximise their asset as best they can. So it might be that uses which are seen as complementary to a town and city centre and providing a good range of shops, well, they may fall away in favour of things which are potentially more lucrative. And obviously that could be accelerated by the current situation where under COVID, we can't do any shopping at all at the moment, or at least not anything other than essential shopping. So is that going to result in a loss of retail? What's the impact of that going to be on the city centre? Now, you might have missed it when I was going through the list earlier, but one of the items which is now within this use class E is any other services appropriate in a commercial business or service locality. Well, query what that actually means. Given that is now something within use class E, it would be open to a landowner to say, well, actually, my proposed use falls within that category. It is and I don't know what it might be. I think the examples that you hear cited are, for example, nail bars and tanning salons and those kind of things. Well, they might, the landowner might say, well, actually, those are all appropriate in a commercial or business service locality, so I want to be able to do that. That might be a use which the local authority may not want to see developing in a what we think of as a primary shopping frontage. So there's and I'm not, I don't know the answer to this. I don't know whether that's what people will do, and indeed whether that's how that particular phrase will be interpreted. But there's that potential there. There's that sort of door ajar in order to potentially have some significant changes of use, which might or might not be seen as desirable. One point which is an area of control that local authorities have got is to issue what's called an Article 4 direction restricting use of permitted development rights. to change uses. Well, those restrictions aren't going to be effective in this scenario, because what we have here is a situation where the changes to the use classes order mean that planning permission isn't required at all. It's just not development for the changes within a use class to take place. So it takes away an element of control that the local authority might otherwise have been able to exercise. So what impact are those changes going to have on policies that the local planning authority might have for protecting the town centre? And then another potential knock-on consequence, which I've just highlighted at the bottom there, the rationale for this change was from the government was actually to improve the functioning and the vitality and the viability of town city centres. But if the actual impact is that it makes it easier for out-of-town sites to change their uses, well, through the law of unintended consequences, might it actually be the case that it has a negative impact on city centres like Canterbury's? So, and these are things which, because this is so new, these are things that we just don't know the answers to yet on how that's going to pan out. So that was I just wanted to flag up some potential consequences of those changes in Class E. And as I mentioned, that's the sort of the bulk of what I wanted to talk about, and we can discuss that afterwards with questions. But what I'm going to do now is just very quickly canter through the other changes that were introduced recently. And essentially, these are changes to permitted development rights. And again, a quick recap. I mentioned before, planning permission is required for development, and that might be built development, or it might be changes of use. Another piece of legislation is the Town and Country Planning General Permitted Development Order. And what that does is it grants planning permission for certain development, physical development, but also certain changes of use. But that grant of planning permission is subject to limitations and conditions, etc., which apply if you're going to rely on those PD rights. Now, there were three pieces of legislation have been introduced in the last, over the summer and into the autumn, and it's the three I'm going to mention now. And essentially, all three of these pieces of legislation facilitate the upward extension of buildings through adding additional floors to those buildings. So the first of those is the one I've mentioned on the screen there, and it introduces a permitted development right to construct new dwellings on top of detached blocks of purpose-built flats. So essentially, if you have a purpose-built flat in a location, there are PD rights in order to put another couple of floors on top without having to get an express grant of planning permission. There are lots and lots of tight constraints around that. For example, it only applies to buildings built between those dates I've shown on the screen, and it doesn't apply in national parks, AONBs, or conservation areas, which is obviously very significant for Canterbury, or to SSIs or listed buildings and scheduled ancient monuments. So again, quite relevant to Canterbury. And it's also subject to what's called a prior approval process, which is essentially a slightly lighter version of getting planning permission. So you don't need to get a specific grant of planning permission, but you do still need to go to the local authority for what's called prior approval. So the principle is already decided, but the local authority has a measure of control through that prior approval process. That's the first of those changes. The second of those changes is a very, very similar right, and it gives the ability to extend buildings upwards, including the constructions of new dwellings above commercial, mixed use, or existing residential properties. And again, the same sorts of constraints that I've just mentioned before apply in this case as well. And then the final one that I was going to just mention briefly is a slightly different right. This is a right to demolish certain types of buildings, and in this case, it's blocks of flats or existing B1 uses. Do you remember I mentioned B1 uses previously being the light industrial buildings? This is a permitted development right which entitles the landowner to demolish those buildings and replace them with housing, and that might be flats or another set of detached dwelling houses. And again, a similar range of restrictions apply to those as to where and when they can't be carried out. And again, as I mentioned before, that's subject to a prior approval process. So that's just a quick canter through some of those changes which facilitate extra building operations through upward extension. Now, there's a slight health warning attached to everything I've just said, because those changes in legislation are currently subject to a legal challenge in the High Court on various grounds, and you'll see there the claimants have said that the government failed to carry out a strategic environmental assessment, failed to comply with the public sector equality duty, and they failed to properly consult on these changes. So these are being challenged in the High Court at the moment. The case was heard in October, and we're expecting a judgment imminently. It's every chance that whichever way that goes, it will then be appealed further up the chain, up to the Supreme Court. So there is a slight health warning against everything I've said, because it is conceivable that those changes might be undone through that litigation. Okay, and so that's just a quick canter through those. And then the final thing I was going to talk about were the forthcoming changes which the government have been consulting on. Now, there's a document that was published back in August, I think it was, the Planning White Paper, and that's called Planning for the Future. And what the government essentially are trying to do is to make the planning system deliver more housing. This is the root cause of the government's changes. They ran a consultation on some proposals during August, September and October of this year, which is now closed. And what they've done is they've set out a variety of proposals, 24 of them, within three broad categories. So planning for development, planning for beautiful and sustainable places, and planning for infrastructure. And I'm just going to highlight some of the key issues that the government have consulted on, because there's every chance that these will ultimately find their way into legislation, next year or maybe the year after. So it might be that we're working under these regimes in the future. So some of the key changes are that what the government are proposing is that land is divided up into three categories. Also, all land in England would be categorised as either a growth area, a renewal area, or a protected area. And as the name suggests, growth areas, essentially, you've got a green light to development in those. We don't know yet how the government will introduce these changes, if they do, but it's likely that if an area of land is identified as a growth area, then planning permission will be deemed to be granted in that area, subject to getting the details approved by the local authority. Within renewal areas, again, there's a strong presumption in favour of development happening in those areas, not quite as strong as an automatic grant of permission, but still the idea will be that those areas will be developed, provided that a suitable scheme comes forward. And then protected areas, which are, the presumption will essentially be against development. These are things like green belts, AONBs, conservation areas, etc. So we'd have this what's more akin to a zoning system than what we're used to at present. This is perhaps, and then the next part that I'm looking at now is perhaps the most controversial area. This is about central government setting housing targets for the number of houses which each local authority is expected to deliver within their area. And this would essentially be nationally set targets using some various criteria, but essentially it's a mathematical formula. And I think the government are actually facing a lot of opposition to this, particularly in the south of the country, where a number of local authorities are concerned that it's going to be the green light for an awful lot of housing that they don't necessarily want to see. So the next area that the government were looking at was what's called beautiful and sustainable places. And essentially this is the government looking to introduce local design codes with a national body that would help local authorities to make effective use of those codes. But again, that's perhaps a centralising measure and taking a degree of control away from local authorities potentially. And then an interesting quote from the white paper is to explore whether, this is in relation to listed buildings and heritage assets, explore whether suitably experienced architectural specialists have earned autonomy from routine listed building consents. I think that's a very interesting concept, and we'll see whether that does find its way into the legislation ultimately. And then the last point I was going to mention on the planning white paper was how they're proposing to deal with infrastructure. Now, those working in the planning regime will be familiar with Section 106 agreements and SIL. And the idea is that in order to deliver infrastructure, the government would do away with those concepts and introduce a nationally set infrastructure levy, which developers would be expected to pay for their development. And then one of the key things which comes forward as part of Section 106 is affordable housing. So the idea under the white paper is that the money generated from the levy would be used to fund affordable housing instead, with the potential for some kind of on-site in-kind delivery as well. So, I mean, there's a huge amount of detail in the white paper, and it's, well, actually, no, that's not quite right. There's a lot of ideas in the white paper, but not a lot of detail. So it's really just a case of seeing how that comes forward when the government digests the consultation. And in fact, I think we've got the lady from Canterbury on the meeting. It'd be interesting to hear their views on what that might mean for the future of the district. So that was it from me. I hope I haven't. It's difficult to know how to pitch these things, whether it's a bit too broad brush and a bit too quick, or whether it's too much detail. I don't know, but I'm happy to take questions on anything that's that I've gone through there.
Lee, thank you so much for that. I know some people on this call will be somewhat or maybe familiar with a lot of that, and others maybe not so much. Just so everyone knows, from I mean, we're involved as well with the Association of Town and City Management and other organisations at a national level, and have prepared responses to government on the planning white paper. Lee, would it be okay if you stopped share? Then we can all see each other on the screen, and I can try and spot people. Thank you, that's fantastic. And I know that was a lot of information, and when Lee and I were talking about this, we're just trying to really make sure we're all aware of this, because it does impact businesses across the city, you know, every business, but also what's going to happen to Canterbury in the future. So please feel free to pop your questions into the chat. I just realized, of course, we're not in webinar format, we're in meeting format, which means we've got just the chat, I think, Rachel, but yeah, just pop your questions in the chat. I can actually see you all on the screen, so if you can raise your hand like that as well. I'm happy to take questions. I'm going to go ahead and just kick off, because some of the things we talked about, I suspect some of you might be wondering about. You talked through the planning implications. So, for example, at the moment, someone could go from a retail unit and change it into, for example, food and beverage. But of course, that might cover planning, but not licensing. Now, I know we're not licensing experts, but Lee, I just wondered if you could maybe go back to that a bit and cover off what that means from planning perspective.
Yeah, so there's various regimes that anybody trying to run a business will know that they need to get all of their ducks in a row in order to run their business. And in addition to getting planning consent for a change of use, depending on what you're changing it to, and you know, a beverage business is the perfect example, you might need other consents in parallel with that. So, for example, an alcohol license or an entertainment license. So you'd need to get all of those pieces of all of those issues satisfied before you could, in practice, implement your change of use, also start operating your new business. So really what I'm talking about was just the planning consequences, but there are, of course, also those other knock-on consequences as well, which you need to deal with.
Thank you. And Karen, I don't know if you were on when I introduced you earlier and just mentioned your role at Canterbury City Council, and I touched on the local plan. I just wanted to ask a question as well, and it may be, Karen, that you could jump in on this. So Lee, you talked through the three different areas proposed in the white paper for national, well, for designation, kind of like a zoning system. So growth, renewal, and protected. Now, Canterbury has parts of it that are designated as a conservation area. Would this, if this comes to be, would it mean that the whole of the city is designated, for example, as protected just because part of it is a conservation area? Is that something we know yet? Oh, Lee, sorry, you're on mute. Oh, Karen, do you want to jump in on that?
Yeah, so it might be easier for me to jump in actually. Yeah, in terms of the three designations that they put through or put forward as a proposal, it's very much as Lou was saying, that the devil's very much in the detail of what does that actually mean, and they haven't given us any detail as to how we go about designating that, but it's very much in the kind of writing that sits with the white paper. It's kind of seems to be that it's up to the local authority to determine which of its land uses it will designate under those three categories. So I think for me, it's very much what policies do we then attach to those three categories and how do we actually operate those. Because as you say, most of the city centre in Canterbury is conservation area, and we've also got World Heritage Site and lots of other designations. So in theory, if you're doing it very simplistically, you would call that protection area, but there will obviously be certain areas that would probably be wanting to develop sites or regenerate specific sites as well. So I think one of the things that's been fed back to the consultation is about the difficulty in actually splitting off and saying just because you're a protection area doesn't mean something can't happen, because we know already conservation areas, it's not just a blanket, you can't do anything in a conservation area. So I think it's one of the devil's in the detail as to how that will actually work in practice.
Karen, thank you. Your screen did freeze, but I think we heard most of that. In other words, we don't quite know the answer to my question. So Karen, thank you.
So just to chip in as well on that, I mean, I think that the role, even though this is very much a centralising, to my mind anyway, a centralising effort by the government, the role of the local authority will be still to develop its own local plan, which will identify these areas. But of course, even that is still subject to scrutiny by the government through the planning process. So yeah, that will be very difficult to see how this works in practice. But yeah, that remains to be seen.
Okay, thank you. And sorry about the delay in the audio there. Natalie, I think you had your hand up.
Thank you, Lisa. Can you hear me? Great. My question really was to Lee in terms of the new E-class and what that means for the changes to former A classes, whether there's any exclusions to designated areas. I mean, you mentioned about the Article 4 reference, whether it goes beyond Article 4 in terms of the conservation area, for example. You know, is there any reference to that in the new E-class?
No, my understanding is that conservation area status or listed building status for an individual premise isn't going to prevent the use of this E-class, because what sort of conceptually and the way that the law works on this is that if it's within a use class, then it doesn't constitute development at all. So it's not, there's no opportunity to rely upon conservation area status or listed building status. You don't need planning permission to change the use of a listed building already, of course. It's about the physical works that happen to that building, which is relevant under the listed buildings regime. So to be within the same use class is going to enable the use to change. Though it might be that if you wanted to carry out some kind of physical change to the building, putting in a new shop front or erecting a new sign or whatever it might be, there are other regimes that may come into play on that. So those physical works may still be regulated, but the principle of the use behind, the actual what the building can be used for, that's something which is it's sort of, as long as it's within Class E, then that's it. You can still do it irrespective of conservation area status or otherwise.
I'm just going to ask Karen to come in a second to comment on the Canterbury's local plan, because it does relate to all of this. Canterbury's in the process of developing a new local plan. So I just wanted Karen to briefly touch on what that means, and also what the next steps are for that, and how businesses can get involved. Now, Karen, I think when you take yourself off mute, we get a little delay when you start talking, but then it seems to be okay.
Okay, thank you, Lisa. Yeah, in terms of where we are with local plan work, we've recently over the summer had an issues consultation on our local plan, which was asking people about what they felt the issues were we need to think about for a new local plan. So we've already got an existing adopted local plan, which was adopted in July 2017. So we've started the process of preparing a new local plan. So the issues consultation was the first step. The consultation ended at the end of September, and we're now analysing all the responses to that. We've had 3 town centre conferences as well, where I know Lisa, for example, came along and presented Canterbury BID, and I know there may be 1 or 2 others of you that were involved with that as well. But what we're next doing is preparing an options stage of our local plan, and the intention is to have that prepared by the spring of 2021, so next year. So we're busy, as I say, looking at what issues have come out of the issues consultation, which consultation also issues conference, as well as specific conferences for each of the town centres of Canterbury, Herne Bay and Whitstable. And we're taking all of that information, also other evidence that we're gathering. So at the moment we're gathering information on things like the economy, retailing, trends, landscape issues. Kind of at this point it's kind of, you name it, we collect information, and then that will feed into our options document. So the next kind of formal stage where you can have your say, as I say, will be springtime of next year. That's when you can feed in further thoughts on, you know, what kind of progress we should be making, what kind of vision we need to be having, where our development might go. The options stage will be quite high level, but it will be looking at should it carry on and do what we're already doing, which is bringing development and growth to Canterbury, Herne Bay and Whitstable, and less so to rural areas, or should we be actually changing that strategy, and should we be looking to grow slightly different areas, or enabling more development in rural areas, or even thinking about things like new settlements across the district. So there'll be lots of different sort of options and scenarios to look into between now and the springtime, to come up with some different options, and then test that with all of you and anybody else that wants to comment on that particular piece of work. The other thing I wanted to mention too, actually, probably a couple of things. One is that we're also going to be preparing town centre strategies for each of our town centres. So that is linked to the local plan, but we'll also pick up on corporate initiatives that the council might be doing, and we'll also try and pick up other initiatives that other people will be doing. So if you've seen the council's district heritage strategy, that very much looked beyond just what council does, but looked at what other people do as well. So again, we're using information that's come through the conferences and the issues consultation to start drawing up a draft town centre strategy for each of our towns, which will include Canterbury as well as a town centre strategy. So again, once we get a bit further down in that work, we'll be consulting on that as well, and we'll be having more discussions about that, and I'm sure in due course I can come back to this meeting, hopefully, if Lisa lets me, and present you with some of that information too, and get your views on that work. Would be really helpful for me. So that's another piece of work. We're obviously, you know, in the planning department, mindful of how things are going out there on the high street. So I think the COVID legislation that came through in terms of changing use is quite interesting, because it obviously gives more scope for flexibility to react to market changes. But I suppose, as I think Lee was mentioning, that there's that sort of, what's the impact of that as well. It's not just, you know, do we have lots of coffee shops springing up, and then what does that do? But also thinking about, as you mentioned, do the outer town centres suddenly start changing into different formats, and more changes happen in those areas? So that's another area that we'll need to think about as we develop both the town centre strategy work and also the local plan work, to see, you know, what are the likely implications of these changes to us, and is that a good thing or is that a bad thing, and is there anything we can actually do to kind of try and manage this process, I suppose. The other thing I'll probably mention, actually, whilst you were talking about the white paper and so on, is that at the moment our local plan we're looking to take forward to the year 2040. So the current plan takes you forward to 2031 in terms of where we want to get to in terms of vision and objectives of growth across the whole district. The new plan will look towards 2040, but the speed with which the government are changing things at the minute, we don't think that's going to impact us in terms of needing to designate the growth areas and other areas if that's what comes in due course. We think our current local plan that we're working on now will probably miss that part of the process. So we think that the current local plan, we won't need to be designating those areas just yet, but as we progress with, and obviously as the government change the white paper and respond to the comments that come back, that we need to be mindful of what they're doing as well as we progress our local plan, and we need to think about how they're proposing to do things in the future. Useful probably to let you know that we were actually picked as one of the authorities to talk to MHCLG about the white paper and how it could be implemented, and what possibilities there were and what are the issues. So we had a meeting with another selection of councils across the country. They kind of picked a few authorities to present the different types of authorities that there are out there. So there's obviously like ourselves, like by district type authorities, but they also pick people like metropolitan authorities from the north and so on. We had a meeting with them, just as I say, to talk around the issues like we've just been talking about, possible implications to help feed into their process of what they might do next. I think hopefully, fingers crossed, we'll still have a foot in the door to keep feeding back anything that we think might be possible, and I think they're probably going to be using us to sound ideas off us as they develop things too. So it's useful for you to know that we've got a little bit of a foot in the door with some of the MHCLG people that are putting these documents together. So that's really all I wanted to say probably for now, unless anybody's got any particular questions about local plan or the town centre strategy work or anything else.
Karen, thank you. And I'm sorry, everyone, if there was a little bit of audio delay there. But I think the main point I wanted to get across with what Lee was saying and Karen, if I could just summarise it in a nutshell, the changes to the class use system, the current proposal in the government's white paper on planning, and Canterbury City Council's local plan and town centre strategies are not just about housing. And I know that seems to be so much about what we hear, but it is very much about your businesses and organizations and what will happen to the city centre in terms of bricks and mortar space in the future. So it's something we all really need to pay attention to. We will be holding more sessions on this. This is really the first to kick off our engagement with the local plan process in Canterbury, and just to get a bit of a background in terms of national government policy. And I know some of you are more engaged than others, but we will be facilitating that and holding more sessions. So Karen, it would be great to have you back. And Lee, thank you for today. We might need to pull you back in the future, just bring you back to update us more on the detail as it unfolds. And Karen, great to hear about MHCLG. I think, you know, that makes it even more important for us to get feedback to Canterbury City Council. Are there any other questions that you want to ask of Lee or Karen at the moment? Okay. We will get those updated slides. Oh, sorry, was that someone?
Natalie's put her
Natalie's put her hand up.
Natalie, sorry. Thank you, Rachel, for looking.
Thanks, Lisa. One more question around the use classes, if I may. Is there any time restriction on these relaxations? Is it likely that, you know, this is the new system that we're working to, and this isn't just the reaction from the coronavirus pandemic and only going to be a year or two down the line?
I think the answer is no. I think it's a permanent change. Insofar as changes in planning are permanent, because, you know, the government, every new government comes in and has their own wonderful ideas about how planning can be improved and changed, and they're normally not wonderful ideas. They just, you know, come up with a new system that's you've got to get used to. But I think that, but these are, on the face of it, these are permanent changes. Some changes to permitted development previously have been very coronavirus targeted. For example, I think there were PD rights to build temporary facilities for testing and for delivering of vaccines and things. There are some coronavirus specific PD rights, but these changes to the use classes order are essentially they're not a reaction to coronavirus, they're a permanent fixture, unless and until the next government comes along and does their own thing with it.
Thank you, Lee. Sorry, Karen, just following on from that, if I can just ask, you know, are the City Council concerned about the relaxations that will apply to Canterbury City Centre in particular, given, you know, its heritage and cultural influences, and what that might mean in designing a strategy on elements that they now potentially won't have control over?
Yeah, I think it's obviously quite early days to work out what the implications are going to be in terms of how many people are likely to run with and change the use of their buildings and so on. But it will be something that we'll be monitoring and as I say, looking into to see if there's, you know, what kind of impacts we think might happen going forward, and kind of reviewing that as we go along and seeing if there's anything that we actually need to do or can do about it. I think that's something we'll keep monitoring really at the moment, because as Lee said, you know, that's the changes that are happening. So we can't do anything about those changes, but is there anything else that we could be doing or protecting, I suppose, in a different way, or using some other planning regulations or rules to try and protect certain things if there are issues cropping up because of it. I think one of the things probably that will assist any particular issues is the other legislation actually. So whereas planning is enabling these things, there is this other legislation in terms of environmental health type issues, you know, noise issues and so on, the license issues with police and so on, that might impact whether these things go ahead. So I think it's one of these things that I think we just need to be keeping abreast of, and what is happening and what impact there might be as we go along.
Well, thank you, everyone. We're coming up to 4 o'clock. So, you know, thanks for taking the time. I know everyone is incredibly busy, but I do really think this is an important subject for us to focus on, and we will be facilitating more sessions. Paula, thank you. Lovely to see you. I know some of you will have to jump on to, I know we all sort of Zoom hop from one virtual meeting to another without time to grab a cup of tea, but thanks again for your time. Do look out for the BID e-news on Friday and comms from Canterbury City Council. There will be more information coming out about how to claim the business grants, the most recent rounds of those, and we'll be getting all the information out as soon as we receive it, and keep an eye out for our future sessions. But Lee, Karen, thank you both very much, and it's lovely to see you all, even though it's on a screen for now. But keep well. And hopefully, yes, someone's just asked about the slides. Yeah, we'll update the slides and we will circulate those to you, as well as post this recorded session and the slides on our website. Thanks, everyone. Bye for now.